Welcome back, everybody. We had expected to be talking about jury selection in the Drew Peterson trial this morning, but now the beginning of the trial is nowhere in sight. It has been delayed while prosecutors file an appeal.
Defense attorney Thomas Gosko joins us now to help sort out all these developments in this case. And first, we want to talk about the appeal. You know, the judge threw out the decision. Most of the hearsay evidence that was a prosecution was based primarily on that. The defense says without that, prosecution has no case. So what happens now?
What happens now is what they've essentially done is filed a certificate of impairment with the court. The states can only appeal in certain matters in criminal cases. And in this case, what they've done is said, your ruling, Judge White, has put us in a position where we can't prosecute. So therefore, we're going to file our certificate of impairment, and we're going to appeal your rulings to the appellate court. You significantly curtailed our prosecution to the point where we don't think we have a reasonable chance of success. That creates a lot of problems. First and foremost, the rule under which they are appealing requires that the defendant not be held on bond absent compelling circumstances. Now, they have filed a motion to keep Drew Peterson in jail, but other than just being Drew Peterson, there really are no compelling circumstances to keep him in jail. I would not be surprised if he's released after the hearing today if they are insistent on going forward with this appeal.
Now, what is the hearing today, then? Is it just about releasing him?
The hearing today is the status for the certificate of impairment to show that the state is proceeding to appeal the judge's rulings, the court's rulings. And at that motion, defense attorneys are expected to then come forward and say, you must release my client at this point. You can't indefinitely keep a defendant in jail while you appeal every ruling. So this is your fault. This is your action. So therefore, you can't punish my client by keeping him in jail.
How long do you expect all this appeals process to take?
That's a very good question. There are no timelines on appeals. It could take as little as 6 months. We could be at Christmas and starting this whole thing over again. It could go on to, into the new year. We could end up with before the Supreme Court, the Illinois Supreme Court, and or the United States Supreme Court based on some of these issues.
Wow.
Are you surprised that he filed this appeal yesterday, the day before the trial was scheduled to start? I'm
surprised he took so long. The basis, from what we've heard, is that he has suppressed, the court has, certain items coming from the hearsay statements. To go forward in a prosecution and go up right to the door of your trial and then say, we're not going to go through that door and proceed to trial, it raises some questions of whether or not he has the evidence to go forward and actually prosecute him absent the hearsay statements, which is troubling. If you don't have DNA, you don't have fingerprints, you don't have a statement, you don't have any direct evidence, are you willing to convict somebody solely on hearsay evidence? And that's essentially what they're saying by virtue of the fact that they're appealing this.
Wow, wow, wow. It goes on and on.
It does.
Well, at least it gives us a chance to talk.
It is absolutely fascinating.
Thank you, Thomas. We appreciate it.
Thomas, thank you for coming in. Right now, we're going to check.